What if your phone could put you in a police investigation, even if you have done nothing wrong? What if a product made you sick, but you could not sue because the government never required a warning? And what if someone with legal status in the United States could still be deported based on evidence that did not exist at the time? This week, a quiet bill in Congress and 3 Supreme Court cases raised the same question. When the law is unclear, who carries the risk? Powerful institutions or the public? That's what we are breaking down today on Wahl on Law. Hello, and welcome to the second episode of Wahl on Law. My name is Jonas Wahl, and I am a sophomore at the University of Delaware, studying political science, criminal justice, and sociology. I created this podcast because there are major legal updates every week that affect our lives, and as a student, I did not always understand what those changes meant for me. Wahl on Law breaks down how the law actually shows up in everyday life, especially for students, young people, and non-lawyers. In today's episode, we are covering 2 major legal updates. First, we're going to talk about a new Republican House of Representatives bill that wants to reform U.S. toxic chemical laws. Then, we will shift to the Supreme Court's April calendar in 3 cases that could shape privacy, immigration, and consumer rights. Let's start with the Republican House bill. On Tuesday, February 10th, a new House bill was introduced that would rewrite major parts of the Toxic Substances Control Act, or the TSCA. According to critics of the bill, these changes will remove key protections for consumers, workers, and the environment. This bill would also limit the type of science used to determine health risks, would stop requiring the Environmental Protection Agency to ensure chemicals won't harm people, and would make it more difficult for the agency to ban toxic substances. As with everything we cover on Wahl on Law, let's break down what this means and why it matters. So, what actually is the Toxic Substances Control Act? The Toxic Substances Control Act, or TSCA, was passed in 1976 and is the main federal law that gives the government power to regulate chemicals used in everyday products. Think about things like plastics, cleaning products, and food packaging. Basically, if it's an industrial chemical, TSCA is usually the law. Before TSCA, companies could introduce new chemicals with almost no oversight at all. Therefore, TSCA was meant to answer one simple question: is this chemical safe for people to be around? The law gave the Environmental Protection Agency, or the EPA, the authority to review new chemicals before they are sold, study chemicals already on the market, and restrict or ban chemicals that pose health risks. On paper, that sounds great, but here's the catch. For a long time, TSCA was incredibly weak. The EPA had to prove a chemical was dangerous after it was already in use. And even then, banning a chemical was almost impossible. Congress was able to restrict a few chemicals under TSCA, with asbestos being the first major test of the EPA's general power to ban a substance. The process to ban asbestos took 13 years, and in 1991, a federal court overturned most of the ban, saying the EPA had not met TSCA's least burdensome standard. After that loss, the EPA rarely tried to use TSCA to ban chemicals. The legal bar was just too high. So because of TSCA's ineffectiveness, Congress updated the law in 2016. It is this update that is now being targeted. So the changes to the TSCA were significant. The update allowed the EPA to have more authority to review chemicals already in the market, required the agency to focus on human health first as opposed to just industry costs, and required the EPA to consider risks to workers, children, and pregnant people. For the first time, the law stopped treating chemicals as innocent until proven guilty. So that might sound confusing, but there's really one important question we need to ask. Did the law get better? The answer is yes, but slowly. After 2016, the EPA began running more formal risk evaluations, and the agency started building records that can actually support restrictions in a way the old law rarely allowed. They also issued stronger findings that certain chemicals posed unreasonable risks and laid the groundwork for bans that would have been impossible before. Now, this might sound underwhelming, and honestly, that's fair. There are 3 reasons why it felt slow. First, let's talk about the scale of the issue. It is important to remember that there are thousands of chemicals already in use. Reviewing them takes years. Second, industry resistance. Chemical companies routinely challenge EPA decisions in court, turning restriction into years of litigation. And third, political whiplash. Different administrations interpreted and enforced the law differently, slowing down momentum and making progress fragile. Still, for the first time, TSCA was actually starting to do what it was supposed to do: protect dangerous chemicals from the general public. And that progress is exactly what this new bill is trying to roll back. So now, we're ready to fully answer the question: what is the new bill trying to do? To put it simply, the bill pushes TSCA back towards the old version that did not work. There's a lot in this bill, but I want to focus on 5 key changes. First, the new bill would lower the safety standard. Instead of requiring the EPA to ensure that a chemical will not harm people, the agency would only have to show that it probably won't. In everyday life, we accept probably all the time. But in law and public health, that word does a lot of damage. Won't harm means the EPA has to be confident a chemical is safe before it is sold. Probably won't means that if there's any uncertainty, the chemical can still be approved. And with chemicals, long-term harms can take years or decades to show up. And if you don't properly test it and let it on the market, and then you find out later that it's dangerous, it is incredibly hard to pull it back. Second, this bill would put industry back in the driver's seat. Chemical companies would get a larger, formal role in the review process, including meeting with regulators while the decisions are still being made. This is like if a prosecutor was allowed to privately talk to the jury while they're deciding guilt or innocence. Even if nothing improper happens, it undermines the integrity of the process. Third, this bill would make bans and restrictions on chemicals harder. Any regulation would have to be cost-effective and reasonably feasible for companies, reopening the same legal loopholes that blocked action for decades. Fourth, this bill would limit the science that the EPA can use. The agency would be restricted in what health studies it can rely on, meaning that industry-funded or biased science would play a much larger role. And finally, this bill opens the door to early lawsuits. Companies could now sue the EPA during the review process, slowing or stopping regulation before it even finishes. So you might be asking the question, why are House Republicans in Congress even trying to roll back TSCA? They have a few arguments. Supporters of the bill argue that the 2016 version of TSCA made the EPA approval process too slow. They say chemical reviews can drag on for years, delaying new products and innovation. They also argue that requiring chemicals to be proven safe sets an impossible bar because science always involves uncertainty. And they claim that chemical companies know their products best and should have a bigger role in the process. So why does this all matter? Because this is not about abstract regulations or technical legal language. It is about who carries the risk when we don't know everything yet. Under the 2016 version of TSCA, that risk falls on chemical companies. They have to prove their products are safe before they are sold. Under this new bill, that risk shifts to the public. Chemicals can enter the market while questions are still unanswered, and we only find out if something is dangerous after people have already been exposed. By then, it's often too late. These chemicals are already in our water, our furniture, our food packaging, and our workplaces. This bill also matters because it changes who gets a voice in the chemical regulation process, giving industry more influence and making enforcement easier to delay. All of that adds up to slower action, even when real health risks are identified. In other words, this bill does not just weaken a law, It weakens the idea that public health should come before corporate convenience. And that's why a bill most people have never heard of could quietly shape what we are exposed to for decades to come. And to be clear, this bill has not passed yet. It is still in the House, which is exactly why paying attention now matters more than after it becomes law. That was a lot to unpack. But now, let's shift to the Supreme Court. Earlier this week, the Supreme Court released the list of cases that we'll hear in April, which is the last month that the Supreme Court hears oral arguments this term. After April, the justices stop hearing new cases and spend the rest of the spring deciding them. This means that if a case is not heard this April, it won't be considered again until October. There are 8 total cases in the Supreme Court's April calendar, but I want to focus on 3 cases that will have the biggest impact on everyday people. First, I want to cover Chatri versus United States. Okello Chatri is a man whose cell phone location data was collected by the police through a geofence warrant. This warrant was obtained while investigating a bank robbery, and he pled guilty, while still preserving his right to challenge whether the search itself was constitutional. Let's break this down. A geofence warrant lets law enforcement collect data on every cell phone that was near a certain location at a certain time, even if the people whose data are collected are not suspected of a crime. In other words, instead of starting with a suspect, police start with a location and then work backward by pulling data from everyone's phones. This means that completely innocent people can have their location data searched, stored, and analyzed without ever knowing it happened, and without ever being accused of a crime. Now, Chatri is not arguing that he did nothing wrong. He's arguing that police violated the Fourth Amendment when they collected cell phone location data from everyone near the crime scene, including him, without individualized suspicion. The concern is that if this type of search becomes normal, the Fourth Amendment stops protecting people before the government looks, and only protects them after the government decides they matter. So this case is not really about one crime or one defendant. It's about whether carrying a smartphone means you're constantly traceable, searchable, and part of a digital lineup, just in case the government might want to look later. Second, I want to cover Bondi v. Wahl. This case deals with immigration law, but not in the way people usually think about it. Bondi refers to Pam Bondi, the Attorney General of the United States. When a government official's name appears first in a Supreme Court case, it usually means the federal government is one of the parties. Wahl is a green card holder the government is trying to deport. The case centers on how much proof the government needs to deport a lawful permanent resident, and when it needs that proof. The government argues that it should be allowed to deport someone based on evidence discovered after that person re-entered the United States. Wahl argues the opposite. If the government wants to deport someone for a past crime, it has to show that it had clear and convincing evidence at the time of that re-entry, not build the case later. So the case isn't really about whether someone committed a crime, it's about timing and due process. A green card is supposed to mean lawful permanent residence, but if the government can rely on evidence developed later, or reinterpret past conduct years after the fact, then that status becomes much less stable. The question the court is really answering is this: how much uncertainty does the government need before it can take away a legal right to remain in the United States? The court's answer to this question can make it easier or harder for the government to deport lawful permanent residents. Finally, I want to cover Monsanto v. Darnell. This case focuses on consumer safety and corporate accountability. Monsanto Company is a major chemical company best known for making Roundup, a widely used weed killer. Roundup has been the subject of thousands of lawsuits from people who say they developed non-Hodgkin's lymphoma after long-term exposure. Darnell is one of those individuals. He is suing under state law, arguing that Monsanto failed to warn consumers that Roundup could cause cancer. Now, the Supreme Court is not deciding whether Roundup causes cancer. Instead, it's deciding whether people are even allowed to sue. Monsanto argues that because the Environmental Protection Agency did not require a cancer warning on Roundup's label, people should not be able to sue the company under state law for failing to warn them. Darnell argues the opposite. Just because the federal government did not require a warning does not mean companies should be immune from lawsuits when consumers say that they were harmed. This case matters because it decides what happens when regulation falls short. If the court sides with Monsanto, it means companies could say, the government did not tell us to warn you, so you can't sue us. People may lose one of their main ways to hold corporations accountable. And fewer lawsuits means less pressure on companies to change labels, add warnings, or fix unsafe products. If the court sides with Darnell, it means regular people can still go to court when they believe a company failed to warn them, and companies cannot hide behind the fact that regulators stayed silent. Monsanto v. Darnell is not just about weed killer. It's about whether companies can avoid accountability simply because the government has not stepped in. Now, because these 3 Supreme Court cases are being argued in April, the decisions should come down by early summer. But it's important to stay informed because understanding the law before it changes is the best way to understand its impact after it does. And when those decisions come down, we'll be right back here breaking down what the court decided and what it actually means for you. So here's the big picture from today's episode. We started with a new House bill that would roll back key protections in the Toxic Substances Control Act, shifting risk away from chemical companies and onto the public, and making it harder for regulators to act before harm happens. Then, we turned to the Supreme Court, which is set to hear 3 major cases this April. One case asks whether police can collect cell phone location data from everyone near a crime scene. Another asks how secure a green card really is and how much proof the government needs before it can deport someone. And the last case asks whether companies can avoid lawsuits simply because federal regulators stayed silent. On the surface, these issues look different: chemicals, privacy, immigration, and consumer safety. But they all come down to the same question. When the law is unclear, who carries the risk? The public or powerful institutions? Before we close out, I want to say thank you for listening to the second episode of Wahl and Law. If you found this episode helpful, or if it helped make the law feel a little more understandable, that's exactly the goal of this podcast. In future episodes, we will continue to break down major legal and political developments, whether that's Supreme Court cases, legislation, or executive actions, and focusing on how those decisions affect everyday people, especially students. If you enjoyed this episode, make sure to follow or subscribe to Wahl and Law so you don't miss future updates. You can also find episode summaries, sources, and more information at wallonlaw.com. Thank you again for listening, and I'll see you next time on Wahl and Law.